Yahoo has accused Facebook of willful patent infringement and demanded triple damages as a result. Yahoo is asking the court to triple the damage award from Facebook on account of Facebook's willful, deliberate infringement of Yahoo patents. There is a distinction when it comes to patent infringement between willful infringement and accidental infringement. The courts compensate the patent holder for accidental infringement, typically by an award of a reasonable royalty. But the courts punish the infringer for willful infringement, when the infringer knew of the patent and infringed it anyway. Triple damages are the result. So if a reasonable royalty were to be calculated to be, say, $10 per unit for infringement to license the patents for selling a product, then if a triple damage award were to be given by the court, then the infringer would have to pay $30 per unit instead of 10. So the costs can really add up. This was an issue, by the way, in the case for the Blackberry, the RIM patents, which when RIM was found to be infringing patents by NTP, and RIM was forced to pay triple damages, and it made the actual payment that was settled with NTP to be somewhere in this area of $600 million. So triple damages are an issue. They are triggered when there's evidence that the infringer is on notice of the patents. The infringer is infringing while they're aware of the patents. Now, they could be formally placed on notice, of course, by a lawyer's letter, or they could simply be placed on notice by someone sending the patent numbers to the company. This often happens in situations where someone's trying to sell patents. They send the patent numbers to a potential buyer. They don't realize the implications that this is placing the buyer on notice and starting the clock ticking on a potential willful damages claim. Often of course, they will send the patent numbers to the potential infringer in order to place them on notice. There really doesn't make much difference as to the reason behind sending the numbers, as long as the company's on notice. Now, of course, the implications are that companies, especially large, sophisticated corporations that are often the target of patent infringement lawsuits, do not want to receive patent numbers unsolicited. They certainly don't want any evidence of infringement to be sent to them, or evidence of their infringement to be sent to them. When sending patent numbers, when you're selling patents, you will often find that the recipient lawyers you send the patents to get very upset if you just send them the patent numbers through an email or through some other form of correspondence. If there's a controversy over whether the company is infringing or not, then the company can file suit, the potential buyer can file suit against the patent holder for declaratory judgment. There's another video on this topic in this series that we just produced that you might want to look at, because that's a related issue of triggering a declaratory judgment lawsuit by sending patent numbers over to potential buyers. Now, one of the results of this triple damages issue is that discussions between buyers and sellers are often clouded in secrecy. The talks are designed in such a way by the potential buyer, the potential infringer, to avoid a trail of evidence that they're on notice. Often the lawyers representing large companies that are often the target of lawsuits prefer phone calls and face-to-face meetings, off-the-record discussions in preference over emails, letters and other written forms of evidence. Now, patent attorneys and patent agents have special concerns here. When they're filing new applications, patent attorneys and agents have a duty to disclose all the patents they're aware of that may have a relevance in this new application to the patent examiners, to the USPTO in the United States. So a patent attorney would often not want to be aware of a patent number because that creates a duty in the attorney to disclose that patent number if it has any relationship to a new patent application that the attorney is filing. So basically there's double trouble if you send patent numbers to patent attorneys that are representing large corporations. They don't want to see the patent numbers because it places them on notice and it creates a duty to them when filing new applications at the patent office to disclose those patents. They don't want to see them in general. So what do? Well, many large sophisticated companies create some forms of Chinese walls within the organization. The patent reviewers are isolated from the product teams, and they are arguably able to review patents without placing the company on notice. So there are certain channels set up for the intake of patents and the review of patent numbers for acquisition that is isolated from the people that are designing products, and the companies argue that this means that the product designers are not on notice of the patents. Although some attorney may have reviewed the patents, the designers in the company are designing products without an awareness of these patents. Therefore, they're not willfully infringing. So this is something that we often see. And this, of course, is another legal minefield to be aware of. No one really wants to pay triple damages for patent infringement, although patent holders obviously love to collect triple damages because that's where the damages go to. They go to the patent holders in these disputes. Take care and take professional advice, again, before sending patent numbers to companies that are producing products, and especially to patent attorneys.